The procedures for election of chairman and deputy chairman are set out in Rule 22 and Appendix 4 to the House Rules. Members may wish to nominate a member to be the chairman, and valid nomination has to be made orally by a member and seconded orally by another member, and also accepted by the nominee. So, any nominations? Mr. Jonis Ho nominates Mr. Holden Chow. Any seconder? I will be seconding this nomination. Mr. Holden Chow, do you accept the nomination? Yes. Any other nomination? Yes. If there is none, so Mr. Holden Chow has been elected as the chairman of the subcommittee. So, Mr. Holden Chow, can you come forward and take over the chair?
我哋按照翻個議程就係喺翻度睇下先嚇，選舉主席與律師肯舉行會議。係啦，就叫佢哋簡介呢兩個 rules。好啊好啊，咁我而家可以叫佢哋入嚟。我哋請緊佢入。好啊。咁我哋就請。
Now let's go into item 2. Can we ask now the representatives of the Law Society to come into the room? All right. Now, may I now invite the representatives of the Law Society to brief us on the Solicitors Professional Indemnity Amendment Rules 2016 and Solicitors Practice Amendment Rules 2016. These two amendment rules are setting out the gist of the amendment, and also the Law Society has a dated 9th of December responding to the legal advisor to the subcommittee's letter dated 7th of December 2016. So can we now ask the representatives of the Law Society to brief us on the amendment rules, please?
I'd like to speak in English because we have two team members English speaking.
Yes. Okay.
We've submitted a legislative council brief, and in that brief we have introduced the amendments to the rules. The rules have been in operation for over 30 years. And during the course of the operation, we have come across some issues in the running of the scheme, and the amendments to the rules are aimed at enhancing the operation of the fund and providing more clarity to the PIS rules. In the Legislative Council brief, we have already put down detailed explanation to the reason why we have amended the relevant provisions, and I do not intend to repeat them here. I would like, in fact, to go to the question raised by the legal advisor in relation to the Chinese translation of the amendments. We have responded to the Legislative Council Secretariat by our letter dated the 9th of December 2016. And in one, I would like to highlight Rule 13, in which the legal advisor raised a question as to the translation. We have explained in our letter that, in fact, in our translation, there should not be any ambiguity, because in the last sentence of Rule 13, we can see that the translation has already highlighted that the provision relates to the dispute in relation to the liability and quantum of the contribution, as well as to the claim and amount of the claim. So the dispute relates to these two items, two aspects, and that we do not think that in the current translation, the Chinese version will raise any ambiguity, and we submit that this version of the Chinese text be retained. We would like to, we'll be happy to answer any questions from members.
好，頭先剛才有委員好似舉咗手。
Just now, members have raised hands. Mr. Junius Ho, thank you. Wow, I have to declare an interest. I'm also a council member of the Law Society. I'm declaring my interest here because of my work duties. But I really don't have a direct or indirect pecuniary interest in the matter. So I must declare that interest. I don't think there is a problem of me attending the meeting unless the chairman thinks otherwise. So I would like to make that declaration first. 5分鐘連問唔答，但我哋如果唔使用咗佢真係有啲大劑。好啊，鎖到。OK。好，我冇嘢問。好，All right, Mr. Junior, so you have, okay, declared your interest. Yes. Well, let's set this simple rule. Every member will be given 5 minutes, including answers and questions. And if some issues go unresolved, and then we can have a second round of questioning. So members, do you agree that we have this time limit? Yes. All right, second member who has raised his hand is... no one yet. Mr. Alvin Young?
According to the Law Society's brief, the current amendments are suggested pursuant to a Queen's Counsel review, and I refer to paragraph B bracket E. And could the Law Society please provide the report of the review and recommendations so LegCo could have a better idea of what the Queen's Counsel suggested? Chairman.
Law Society representatives, please.
Your question is directed at the Law Society's provision of the Queen's Counsel.
No, I am referring to your brief to LegCo, Chairman, paragraph B bracket E, and in the paragraph, it is suggested that the board has instructed a Queen's Counsel to conduct a review and have done some recommendations. So I am wondering if the board is convenient to supply the review and recommendations to LegCo, to us, so we could have a better idea of what the Queen's Counsel suggested.
Queen's Counsel's suggestions are actually implemented in the current form of the amendments.
So, Chairman, is that so? Does it mean everything that the Queen's Counsel suggested have been adopted to the current amendments, Chairman?
Yes, the original suggestions for the amendments actually came from the Solicitors' Indemnity Fund and or the Council, but because Sorry, is that?
Yeah, thank you.
Sorry,
please,
apologies.
Please carry on. Yeah.
I said the original suggestions for all the amendments to the rules, which impact on the operation of the scheme, came either from the professional indemnity scheme, the company, or the council. But because the rules are fairly complex and changing a small paragraph may impact other provisions in the rules, it was thought prudent to get a senior counsel to take a look at our suggestions and give us a tick, if you like, on the drafting and make sure that we'd achieved the objects that we wanted to. So the suggestions did not emanate from the QC. The QC was simply responding to the suggestions from the Solicitors Indemnity Fund and the Council.
So, Chairman, I'm just simply asking, is it convenient to have a look at the report, or is the representative from the Law Society suggesting that it is not necessary because what the Queen's Counsel suggested are very trivial, or everything has been fully adopted to the current amendments? This is my only concern, Chairman.
So would that be available, that sort of report? Or as you said, that all the Queen's Counsel reviewed opinion has already been incorporated in this draft amendment? That's correct, yeah?
That's correct.
Okay.
So it has been fully adopted?
Fully adopted.
Okay. And my second part of my questions, is it convenient for the Law Society or the Board to provide a report on the financial status of the fund and some breakdowns for types and amounts of claims, say in the past 3 years, so we could have a better idea of the status of the fund, Chairman?
Yes, please.
Yes, certainly. I mean, the fund has audited accounts. The fund has audited accounts, and as managers, there's a manager of the scheme, and we provide a quite comprehensive claims report every year. We have claim statistics on the professional indemnity scheme going back to 1989, so I'm sure that the latest claims report is very easily shared, if that would be of interest.
Very well, Chairman. So when are we going to have the relevant documents?
Can you provide a timeline, or?
Well, I can put them in an email when I get back to the office.
Okay. So this is an undertaking, I assume.
Okay.
Yeah.
Okay.
Thank you, Chairman.
Okay. 跟住咧就請郭榮鏗議員。
Mr. Dennis Kwok, please.
I have similar questions, but these questions perhaps do not relate directly to these amendments, but they are of significant interest by members of the profession, and especially in relation to the financial status of the fund itself. Now, I understand there is always published reports about the financial status of the funds, but it is sometimes quite hard to understand the amount of discount that you put on the premium each year. Now, I understand that in recent years you've given up to a 50% discount on the insurance premium payable by members of the Law Society, which is encouraging, but I was just wondering whether there are room for further reduction in the future. The reason I ask is because for many of the practitioners this is quite a heavy overhead, and that we are trying to reduce the burden on them to see if there are further room for reduction, because I understand the fund is actually doing quite well in terms of its finance, and there is a huge financial surplus right now. Can you give us the figure and tell us whether there is further room for reduction for the premium? Thank you.
You round up, the current reserves are approximately 2 billion Hong Kong dollars. We are aware of the concern of members. If I may, I would suggest we don't use the word surplus, because we are a mutual scheme, so these are in fact reserves, and there is just a level of prudence which must be maintained against any future claims that might arise, and that obviously protects not just the profession but also the public. But having said that, we are aware of the concern of members. The reduction in contribution was first made in 2010-11, and you're quite right that this last year the reduction went up to 50%. There is inevitably a tension between the role of the board of SIF and the council, because you will, I'm sure, understand that the role of the board is to make sure that the fund is prudently managed. Okay, so they have to take into account the interests of members as well as the protection of the public.
I understand that, but there's a $2 billion, whatever you call it, the surplus. Reserved. And what is the average claim against the fund on in the past few years?
Our average claim figure is around $3.5 million.
Okay, so you've got more than enough to cover, going forward. So there should be scope for further reduction of the premium payable by solicitors. Is that right?
I think, as always, when faced with this decision, the board takes prudent actuarial advice. And in the past, the actuarial advice has been that a reduction is justified. So yes, I mean the precise amount of the reduction obviously is a matter of some discussion.
Okay, thank you. I look forward to seeing further reduction on the premium for solicitors. Thank you.
Thank you.
Next, Dr. Priscilla Leung, Chairman. We are talking about subsidiary legislation. We have covered this topic before. This is the new term of LegCo, and we have new members. If members want to be provided with extra information, we should do so.
Interest with the interests of the profession. In fact, of course, most members are practitioners here, either barrister or solicitors. We do consider, of course, the situation of our fellow members in the legal profession. But at the same time, from the point of Legislative Council, we do need to also make a good balance for protection of public interests. As you know, legal services receive high respect and confidence from the public. And if in case anything happened, those ordinary clients and victims should be reasonably protected. So I myself, I'm open. If you do consider that there is really a lot already for reserve, we can consider reduction. But really we have to bear in mind the public's interest is there. As when we discussed, I remember in the previous terms, talking about a professional indemnity. Actually, that is for the public, as well as a sort of a joint responsibility that, like, everyone try to share a bit if in case some law firms go into problems. So I want to raise this issue from a broader scope also, as we have members who raise it. And Chairman, I do think that I can see from the question raised, we might need, when you it's convenient to you, provide some brief background so that members follow each provisions much more easily and effectively. We hope that we do not need to hold too many meetings for this subsidiary legislation that the profession is also waiting. And maybe legal advisor may have some points that if you would like to add, because you might be most familiar, or questions that can help speed up the whole process also.
Maybe the representative from Law Society and also legal advisor, any?
Yeah.
No, just to basically agree with that, and that's what makes the contribution reductions quite a tricky exercise, in that we obviously, from the members' point of view, it's in their interest for the reduction to be as large as possible, but from the public's point of view, we must ensure that we have the reserves to meet claims. So it is a balancing exercise of both those interests, and that's the fund is set up to take into account both those sets of interests.
Yeah, maybe I follow up. I mean, we don't want to look too arbitrary, you know. So when we are talking about a reduction, we also need to convince the public that, well, because the reserve is enough. I mean, we also need to make sure the legal profession is not just looking at the interests of the profession, but also is considering the public interest. So any change, any amendment, you give us more statistics, and so we give a very good explanation and account to the public That is what I request. 法律顧問會唔會有嘢
Okay.
Anything to add from the legal advisor?
Opinion or view?
Thank you, Chairman. In terms of the drafting issues that I raised in connection with the Chinese text of the indemnity amendment rules, I tend to agree with having considered the Law Society's response, I tend to agree with them that the issues wouldn't affect the meaning of the provisions. As such, I don't have anything further to add. Thank you.
Thank you. Any other questions? Other member? I personally have one question only. Referring to the Schedule 3, there's a new paragraph 8.1d is a new provision added, and it describes that the company has a discretion to take over the conduct of the claim on some circumstances. So would you mind tell us a little bit more on what sort of circumstances, apart from on your brief you said if the sole practitioner who has passed away, I would like to know if there are any other circumstances that the company would exercise that specific discretion to take over the claim directly.
Very, very rarely. I've been involved with the PIS for many years now. I've never known the company take over conduct. The present provision is a little bit illogical in its operation, because there's no reason why, if the company does take over conduct, why those costs do not erode the limit of indemnity. I can envisage a situation where an indemnified wishes to contest a claim, the company doesn't. We exercise the SC clause, and the SC clause finds in the company's favour. But nevertheless, the indemnified may insist on defending. Now, this provision now allows the company to step in and take over and therefore compensate the member of the public. If we think that, you can see that an indemnified may not be able to satisfy any adverse costs order. And so if in our view, supported by an SC, the matter really should be settled, that gives us the option to step in and do that.
That will be in the interest of the
public.
In the public too.
Yeah.
Okay. And that would expedite the entire progress, because if you step in, then you would avoid further dispute on that point.
Well,
am I correct?
Depending at this, we can step in at any time. So yes, if we decided to step in before trial, then yes, we could settle before trial, save the defence costs.
Okay. And that would be regardless of the opinion of the law firm, the indemnified.
Yes.
And okay.
Because the way the scheme works is that the defence of the claim is a joint retainer between the indemnified firm and the company. All right, we're joint clients instructing the defence solicitors. All right, so obviously we have to agree on all major steps in the litigation, and if there's a dispute at the moment, then that's only resolved by reference to the SC clause. But with this, we can actually take over conduct if required. But I've never known it be used.
So that would be rare.
Very rare.
Rare circumstances.
Very rare.
Okay.
Yeah.
Okay. Cool. And my opinion is, I think a lot of members of this panel have already raised. We pretty much look forward to the reduction of the premium, because you see many of our fellow legal practitioners face a lot of burden,
of course,
on the premium, and probably you would understand. Yeah. And Mr. Ho, yeah.
Yeah, Chair, maybe in this regard, perhaps it is not directly existing proposed amendments that the Law Society is seeking for. Anyway, if any member of this committee is interested about how the Law Society function or has been trying to achieve some sort of the reduction in the premium, I think the Law Society may provide some of the schemes and some of the decisions that we had taken for the last 5 or 6 years, and that actually provides a substantial reduction in terms of the premium contribution. So that's actually a very issue that the Law Society has been considering and in fact implementing. So that may also help members to understand how we operate better.
Sure.
Thank you.
If I may add as well, because the Law Society and the board is very aware of these issues. In addition to the contribution, there are other ways in which the cover provided under the professional indemnity scheme may be enhanced, and that is part of an ongoing working group. So we're looking at things like revisiting and reviewing the limit of indemnity, perhaps putting back into the rules cover for innocent partners, which is presently excluded, potentially looking at cover for disciplinary proceedings, that arise out of a practice, not law society disciplinary proceedings, but regulatory proceedings of other sorts. So I think there is a general a general movement towards maximising the value of the PS to members.
Well, sorry. Has she answered your question? Fine.
Well, in fact, I'm just inviting the Law Society to provide more information about how we implement the reduction for our members. I mean the Law Society members, so that this information can be also provided to the members of this committee for better understanding how the Law Society operates in terms of getting ways to reduce the premium contribution. Actually, it has been happening for the last few years. There has been 33% reduction, the cross subsidies by the PIS scheme in favor of the law firms. So that's actually happening. That's my invitation to
I can give you that information now. Starting in 2010, the reduction has been 33.33% for every year except 12-13, and then in 16-17 it was 50%. So the reduction has been going since 10-11.
Every single year you have reduction?
No, there was no reduction in 12-13.
Okay, in 12-13 there's no reduction, but apart from that, almost every single year there is reduction on over 30% of the premium.
Yes, correct.
Not bad, isn't it? Not bad, yeah. But I also noticed that there's one more good thing on the amendment, because I read from the proposed amendment on the situation that if there is any dispute between the indemnified and also the company on whether there should be any settlement, and I think previously you would appoint, the Law Society would appoint a senior counsel to give opinion. But now it's only appoint a counsel only, so that would save us a lot of cost, isn't it? Yeah. So
depending on the counsel.
Well, that implies probably we have more chance to get more reduction, isn't it? But anyway, yeah. Okay. So I think members, Mr. Hui, or any other question? Yeah. Okay. Okay. So okay. Hold on. Okay, so okay, 好 ，OK， 好，好，中英文哦，好，我問下佢哋啦，好嘛，好嘛，同時咧，咁我
members, we can now move on to the amendments in the provisions of the rules. The Law Society would go through these with us, and we are looking at paper LBCB 426716217002. So this is the paper we are looking at. Barring any objections, let's go through that paper together, and we can look at the amendments. And if you wish, you can raise comments anytime. Should we look at the Chinese or English version, members? English version? All right. Okay, let's look at the English version.
Back to the paper number CB bracket 4267/16 to 17 bracket 02. We'll go through all the proposed amendment. Yeah. Okay. Okay. So let's start from page 1. There's no amendment. So from page 2, we have some interpretation on the former practice. So there was a deletion for the purposes of schedule. And former principle, the deletion for the purposes of Schedule 1, 2. Then we will go to page 3. Page 3, we read on the panel solicitor, the definition. There was amendment on the definition on panel solicitor. And also we have a extra word added on qualified. Is that the qualified, or which way is that?
They added these 3 paragraphs to the definition of practice.
Oh, okay, yeah. So apart from the amendment to the definition of panel solicitor, there are 3 more sentences on JKL added to the definition of practice. That is probably including the practice on China appointed attesting officer and also the civil celebrant of marriage. Yeah. So you have widened your scope of indemnity, right? Okay. So any problem on that? No? Okay, then we will carry on page 4. I think there's a amendment on the related cost. The related cost is the amendment is probably you add there's A and B. Any problem? Actually, I also mentioned that on the on Schedule 3 on the paragraph 8D. So I have done my question already. Okay, so we move on with the provision of indemnity on next page. So the I think is Part B. The deletion, actually the sentence on costs and expenses incurred blah 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 has been removed, and it was replaced by the word related cost. Okay, no more problem.
And related cost is a defined term.
Yeah, related cost has been already defined earlier. Yeah. 有關連用費嗰度嚇。
Related costs have been defined already.
So we move on section 13, the disputes. You cross out the first sentence on any dispute or difference, blah, blah, blah. You just substitute by subject to paragraph 8, 1C, blah, blah, blah. And the quantum of any claim, blah, 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 has been removed, and quantum of any claim in respect of which indemnity is to be provided is replaced. Any problem? No? No, we go through to, we move on to next page, and there would be 17 on the panel of firms of solicitor. The original version was removed and substituted by the subparagraph 1 and 2. So that allows us to appoint a firm of solicitors which is not on the panel, based on their merits, right, on their area of practice. So we are allowed to do that. In other words, I think we probably have more choice. Okay? So if there's no problem, we move on to the next page on Schedule 1. Schedule 1, I think they just simply remove the bracket rules 2, 4, and 9, replaced by RR 2, 4, and 9, and Schedules 2 and 3. Okay, so next page, there's no amendments, I think. And then we move on to page 10. Page 10. Okay, page 10. Page 10, the I think paragraph D, there would be amendment. It was removed and substituted by the new paragraph on the principle making good all failures, blah, blah, blah. Any other problem on that particular paragraph? If no, we move on. Move on page 11 and 12. There's no amendment. On page 13. On page 13, we insert paragraph 5 on the interest on overdue contributions. There's a brand new paragraph. So Any other question on the interest? If no, we move on. Paragraph 14, Schedule 2. Schedule 2, I think you have removed it, paragraph 2, subsection D, on the words "and compromise." I think you did raise that question in your letter, do you? Or no? Okay. Okay. Oh, okay. If the representative from Law Society would be able to explain a little bit more on the reason on deleting the word "and compromise." Or?
we spent quite a long time discussing this in committee about was there a difference between settlement and compromise. We looked at all kinds of cases and dictionary definitions. In the end, we decided we couldn't make a distinction, and therefore, just for the sake of better drafting, we would just...
Okay. Okay, members happy with that? Right? Generally speaking, I think settlement includes compromise, isn't it? Yeah. But feel free to raise the question because... okay, so I think that that's number 14. So we move on to page 15. Page 15, there's amendment on the wordings of fund and these rules on paragraph D, and also we insert a sort of a new paragraph, or the company acting in good faith, blah, blah, blah. Any other question on that particular paragraph? No? No, then we move on to page 16. Page 16, on the exclusions, the company may pay or include, that was deleted, and we add a new paragraph: at any time pay or include in any payment made out of fund, blah, blah, blah. And then we move on to the next few sentences of the, we have removed another sentence and substitute by the sentence of the deductible applicable to that payment, as the company may request an interest on the amount, blah, blah, blah. And also we add the words on the former principle, each principle and former principle. Yep. And I think paragraph B, we substitute with a new paragraph: if in relation to any claim there's no admission or finding or acceptance of blah, 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 the company may waive in writing or hold the right to be reimbursed, something like that. So any other question on that particular amendment on exclusions? Members happy with that? Okay. In that case, we move on to page 18. Page 18. We have deleted the paragraph, is it 10? Paragraph 10, subsection 10, which arises from circumstances or occurring when a receipt has not been issued to indemnity, blah, blah, blah. So that was deleted. And also on subsection D, direct or indirect loss by the indemnified of the amount of his fees or profit costs and disbursement. And disbursements is deleted. Any other question on that too? No? Okay, then we'll move on to page 9. Sorry. Yeah.
Consequently, after deleting the subparagraph 10, do we need to renumber 11 to become more upgraded into a new paragraph 10? Is the numbering, do we need it? Just a minor.
A minor one. So
minor
simply
question.
move up to...
after deletion of the
so now the section
10.
11 will be section 10. Yeah.
The 11 will become 10.
Okay.
Yeah.
Did we not do that already?
Yeah, a legal advisor.
Yep.
Yeah, please.
Thanks, Chairman. I think because there could be cross-referencing issues if you renumber the paragraph. So I think from a drafting perspective, it may be better just to delete it as omitted or deleted.
I see.
Otherwise, there may be other provisions which refer to Roman 11 X1, then that would cause all kinds of problems.
Got it.
But in the new version, when it is duly released on the day, and there will be the new number substitute, isn't it? You mean? Yeah. Right now, of course, I understand, because for reference purpose, we have to do it.
I think it's really a question for the DOJ, really, when they promulgate a new amended version. But as I explained before, the better course would probably to just to add an annotation after the deleted paragraph Roman 10 to say omitted or deleted, something to that effect, so as not to change the numbering, because that could have cross-referencing implications.
May I ask a question on paragraph 10, actually? It was duly deleted. This provision is talking about on the circumstance that the company will not provide indemnity to the indemnified or a former solicitor in respect of, and then we have all those circumstances. So paragraph 10, which reads, which arise from circumstances occurring when a receipt has not been issued to the indemnified under Rule 9 because of the failure of any principal to comply with any provision of these rules. So I think, please correct me if I'm wrong. So in the past, obviously, if there is a failure of the principal to comply with the rules, obviously you would not indemnify them. But right now, because you delete this clause, does it mean that if there is a failure on the principal to comply with these rules, you still have discretion to indemnify them? Yeah.
It's an expansion. Excuse me. It's an expansion of cover. So the indemnity era under the PIS runs from the 1st of October to the 31st of September. 30th of September, isn't it? 30th of September. So, and under the rules, all the indemnified firms must submit their gross fee incomes within that timetable. Sometimes firms are late, not many, and therefore the receipt that we issued is delayed. Now, under the old rules, technically, if a claim arose in that period, then we wouldn't provide indemnity.
I see.
But now we will.
I see.
Yeah.
I see.
Yeah.
I see.
But the provision of indemnity is not so much a discretion as it must be provided within the terms and conditions of the rules.
Okay, I see. Yeah. Oh, right. Okay.
It links in with the redrafting of Special Condition 9 at the end of Schedule 3.
Okay. I think to answer Mr. Ho's question just now, you raised the point that whether the number should be substituted on paragraph 10. I read some of the reference on the law. If it would read like repealed, it reads like repealed on
such and such a
yeah. So that we will just simply leave it blank and with the wording repealed, so that we know that we have actually removed that particular paragraph. Yeah, and please. Legal advisor.
LN number reference, just so you can check which instrument did the repealing.
Thank you.
Thank you. So we move on to page 19. Page 19, the deductibles for the purposes. Yeah. So it is substitute. And page 20, it seems that there's no amendment. And page 21. Page 21, there are a few amendments in respect of any on Section 4. And on Section 7, the non-compliance, actually the number of the provision has been changed. On 1, bracket 2, bracket C, bracket 7 is substitute. And
previously there was a typo. They omitted.
Oh, okay. So previously the bracket 2 was omitted. So now we need to insert that back. And how about the provision, section number 8? Section number 8, the word withheld, the whole paragraph has been removed. And what has been inserted?
What they've done is actually they moved this bit to 8.1d.
Oh, right. Okay. So they moved the paragraphs entirely to 8.1d, isn't it? Am I correct?
Yes, you are.
Okay, yes. So page number 22, section C is actually removed. and substitute by a new paragraph. Item 1, if a difference or dispute arises between the indemnified and the company. Oh, that's the question I raised, yeah.
Correct.
Because right now we don't need senior counsel. We only need counsel, so that will save our cost. We got another chance to have further reduction on the premium then. Right, okay, let's move on. And we have subsection item 3. The removal of the senior counsel, yes, that is referring to the item 1. We don't need the senior counsel anymore. We only need counsel. The counsel will be replaced. Okay, so the last thing is to add subparagraph D. Subject to subparagraph bracket C, the company may, in its discretion and at any time, take over in the name of indemnify the conduct of the defense or settlement. That's the question I raised earlier. Yeah, on what sort of circumstances would that happen? But as you mentioned, there's rare circumstances. Yeah. Okay. Right. Any questions, members? If no, we move on to page 23. Page 23. Subsection 2, the indemnified must notify the company. The previous sentence shall procure that blah 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 has been removed, and the claim and we insert paragraph C, subparagraph C. Any circumstances of which the indemnified becomes aware during the period of indemnity and which may bracket blah blah blah.
They effectively moved subparagraph C3 to C. Instead of take 3變到 B C.
Oh, okay. So actually, subsection 3 is replaced by the item C, the whole thing, right? So and then the subsection 5, if due notice is given to the company under subparagraph 2B or bracket now is bracket C, it's no longer bracket 3, because bracket 3 has already been removed and inserted with replaced by bracket C. Okay. So on subsection 10, on request, the indemnified shall give all information and assistance that the claims committee or panel solicitors may reasonably require, just to add the wordings or panel solicitors. Yeah, okay. Right. The last page, special condition. The original paragraph is removed and we insert a brand new paragraph on special condition, which is split to subsection 1 and 2. Okay, so any other question on that? Right, if there is no more question, I think we have gone through the all proposed amendments. It seems that the members are all agreeable to this to these all proposed amendments. We go back to OK.
03
哦，呢個係邊個嚟㗎？即係呢個嚟㗎。OK， 呢個係第二個係咩？OK。There is another one. This should be the last one, yeah? Okay, the last one on the, what's the heading of that in the Solicitors Practice Rules, 2B letterhead. I think the Chinese wordings is changed. 中國委任的見證人員呢，而家就要改返，就係中國委託公證人。
The rendition of is changed from 中國委任的見證人員 into 中國委託公證人。
中國委託公證人改返個正確名啫。
So the name, the Chinese rendition 中國委任的見證人 will be corrected.
Through the draft and it's all agreeable to us and the okay. So I think members agree to the view submitted by Law Society on the particular letter they have submitted earlier on, and also the response of the legal advisor. It seems that We don't insist on any further amendment on that Chinese wording, so we would adopt the view of the Law Society. And in that case, I think we have done this all draft amendment. Okay? So I... Yeah. Okay. So, okay. Would the Law Society representative be able to tell us when would be the proposed commencement of the rules, the new rules? Yeah.
We haven't actually discussed the precise dates, but we have no reason to I mean, we may as well just pick a date as soon as possible. There's no
timetable yet?
There's
okay. Okay. Legal advisor, please.
Thank you, Chairman. Does it have to coincide with the commencement of the new indemnity period? No, okay.
No, it doesn't. So, in fact, we could issue the notice, and it could commencement date could be
as soon as
practicable.
Practicable, yeah.
Okay.
Yeah.
Okay. Well, yes, my colleague has just reminded me that according to the time schedule for our work, I think we will. We have already extended the scrutiny period of the two amendment rules to 18th of January 2017. Okay, so on the 6th of January, we will go through the House Committee first. And then on the 18th of January, we'll report to the Legislative Council meeting. Yeah? Okay? Yeah. So I think probably after 18th of January.
Okay. Thank you.
It's just a due process, yeah. Right. So I think members would agree that there's no need to have another meeting, right? We have done all this, right?
I think we have just done it
we have just
beautifully.
Done it.
Under your leadership.
I would agree. Yeah. Okay. Right. Okay. So in that case, I have to thank all the representatives from the Law Society, and thank you for all your good effort in drafting these amendment rules, and thank you for legal advisor and all the colleagues on all your effort. Yeah. So I think the meeting is done today. There's no need to have another meeting. Okay. Thank you. Thank you.